Hello, and today in this video I want to have a look at the statutory intervention into the doctrine of frustration. So it's the Law Reform Frustrated Contracts Act 1943 which deals with this. Prior to this we had the Frustrated Contracts Act 1988. It's better to use this act because it's more recent and it's more used for law. It's what's likely to be used as opposed to the 1988 law. So the whole idea of this act was to deal with the hardships presented by cases such as Paradigm and Jones 1647. But the act itself has created some hardships because it's put, certain restrictions when you can do what, and so, these other circumstances are not counted within it. It's like a box, it has to fit this, where there will be some cases who just don't. So the Act deals with three specific areas. One is how you can recover money that you've already paid in advance to the contract, how that is up to the court's discretion about which party is rewarded for what kind of work, and how you can recover for partial performance of the contract. So the first one, recovery of money paid in advance of the contract. So money that has been paid before, money that has already been paid under the contract before the contract became frustrated, you can recover it. And this is following the Fibrosa case, whereby the law was changed, saying that actually you can claim money back because it's to do with fairness. As well as having this whole, sanctity of contract, you need to have an element of fairness. So if somebody has paid and there's been, no consideration or anything like that, then they should be able to recover their money. And the second part of this money paid in advance is that where you were supposed to pay money in the future but the contract's become frustrated, you don't need to pay that future amount. So this follows Taylor and Caldwell, where they don't need to pay for the rest of the music hall as it was burnt down, the contract was frustrated. Or for example in Appleby Meyer 1967, where the benefit was destroyed by a fire, so therefore you don't need to pay the sum that you were going to pay under the contract. So the second one is that under Section 1.2, the first part as well, the recovery of money, that's under Section 1.2 as well. Under Section 1.2, the court also has discretion to reward a party who's carried out work under the contract. So, under the contract, one party may have already started working when the other party goes, sorry, I can no longer fulfill my duties because the contract is frustrated. The court might reward that party who's already done work. And this goes on, this ties into point number 3, where there's been partial performance of the contract. So under Section 1.3, the court can allow recovery for partial performance where the other party has conferred a valuable benefit on the other party. So if you and I enter into a contract and I've already got some benefit, it doesn't have to be financial benefit, and there was no consideration, nothing else, then the contract became frustrated, then you can reclaim this. It's like the money, but it might be some other valuable benefit, and the courts will turn this into a monetary amount. And the other part of partial performance is up to the discretion of the court to decide what is reasonable. So although this act brings in that yes, you can recover money, and it sets out some of the stuff, everything is based on court's discretion, and that's why the doctrine of frustration is largely built around case law. Thank you for watching.